Well, thank you for coming. I think we have mostly paralegals and some guests in the back. I think they saw some television yesterday.
Kathy said she saw
Really?
the last part of it.
Yes, autographs there.
Yeah.
Couple things. Maybe we can very quickly kind of go around the room, everybody say who they are and where you work. So I'll introduce this young man. This is my friend Paul. Paul is a racquetball buddy and he's also a technical guy. So this is on the internet, and I think Jennifer is watching as we speak, and it's being recorded, so it can be posted on our website.
Oh, okay.
You want to start?
Okay. Olga Braviova. I am a paralegal in Hospital Carnegie. And I'm Kathy Begg. I'm a paralegal at Hoskin Freenham Camp also.
Penny Landis, Hoskin Freenham Camp, paralegal.
Angela Foster, Hoskin Freenham Camp.
Who's working in hospital?
I don't know, but we're here.
So the lawyers are
Lost. No.
Jamie.
Hi, I'm Jamie Wayland. I'm with Ireland Support Team. Lori Dry, Colorado Legal Services. Chris Evers, Susan Eggert, and making contract work with them. Paul Moore, Edinburgh. Patsy Noah, visitor. Peggy Poitier, visitor also. Diane Lucero, visitor also.
Fun. They should have
Welcome.
badges.
And I'm Rob. I work for Alpine Legal Services in Woodland Springs, and also work for well, what I was going to say is that I imagine everybody in this room, except maybe the visitors, know I'm probably the least experienced paralegal here, and really only got the certificate from Colorado Mountain College, I don't know, a year and a half ago. It's pretty recent. And my capstone project was multiple assignments by multiple lawyers, but one of them was with Mr. Moore, and he was very patient. And I think he was, oh God, damn it. But he was very instructive, and I appreciated your time. Sure, I appreciate your time. So Drew Moore is an attorney here in Manchester, specializes in elder law, and topic today is long-term Medicaid.
Well, our topic today is Medicaid and other forms of public assistance. And also, just so you know, I do have some stuff that I was going to go over. I was included in your agenda items, but it's more fun if you have questions you would like to ask. That's fun. Go ahead and interrupt at any time. Raise your hand. I'll call on you. Say the question because there's somebody, I don't know where this one is. I don't know where this one is either, the one on the phone and the one on the computer, but I'll repeat the question and then we'll talk about it. So just generally speaking, I was going to go over some Medicaid topics, and we can stray off of that. We can keep on point. If you have scenarios you'd like to bring up, feel free. I think it's helpful if you do it in the setting like this so other people can benefit, they can hear, and that way everybody can maybe get a little bit better understanding. So I'm just going to go over a couple of points after we go over the basics of what I was going to speak about today, which is Medicaid. We can go over a lot of aspects of Medicaid. I was going to hone in on the long-term care services because it's what I deal with more often than anything else. You know, Medicaid is a program in Colorado. It's a hybrid federal-state program where Colorado's participation is exactly 50%. So the total cost is split between the state 50% and the feds 50%. That's how we pay for it here. Different states have different rates of what are called participation. Here in Mississippi, they pay 11%, the feds pay 90 or 89, whatever the difference is. But we're a 50-50, so we pay for half, the feds pay for half. Medicaid is basically our form of means-tested, in most cases, means-tested medical assistance. So the typical case that I see, and the reason why I even do any Medicaid planning at all, is because we have a large elderly population, and I either have a typical scenario as husband and wife, or children and their adult parents, and they're trying to help parents plan for needs. And typically we're looking for who's going to take care of mom or dad, or who's going to take care of loved one or spouse. So Medicaid, by the way, just so that there's not any confusion, is means tested, and that is one fancy word for welfare. So we are talking about a program that is designed for people who can't afford to pay for their private costs. So, you know, the first thing I like to tell people is when they come in and say, well, I don't want the state taking all my money. Well, they're not going to take all your money. What you really need to say is you don't want to pay the cost of the nursing home. Okay, so you don't want the nursing home to get your money. Let's start with that. So the state rarely gets, well, they get your money, but it's hard, and we're going to talk about that. That's a state recovery. So typically we're wondering who's going to help pay for the cost of long-term care or home services or assisted living in a family that, you know, may have what we call modest means and also, you know, not the best income, but we might have some income. So we're going to go over two scenarios today. One is going to be the single person that you do planning for on a typical basis. And scenario number two will be the family, meaning I should have said family, husband and wife, and I shouldn't have said that. What I should have said is spouse and spouse or whatever, husband, wife, wife. So those are the two basic scenarios, okay? So if there's any questions, once again, at any time, feel free to raise your hand. We'll stop. I'll ask you to say your question. I'll repeat it so those that are not here will hear it, and then we'll dig into it. Also, if you want to get into other areas where you're like, well, where does this, you know, intersect with, for instance, family law or such, those are also good questions and phrases. So let's go over the basic areas for eligibility, just generally speaking for Medicaid. And we're going to go over 5, of the 5, we're only going to talk about 2 in any great detail. What are our 5? Do you have to be a US citizen? You don't. You got to be an LPR though, lawful permanent resident. That you do have. We do have some very limited forms of Medicaid for undocumented, but it's so limited. Frankly, I tell people to go to Arizona. So typically we're looking for citizenship or LPR, which is lawful permanent residence. We have to have something legal to being here. Number 2, you're going to apply to the county of residence. So we want to look at, do you have a right to be here? And are you applying in the right county? Medicaid in Colorado is administered county by county, and it's administered by the Department of Human Services. So they will be the first point of entry for all Medicaid applications. In some instances, the application is going to be vetted by the state, but everything is single entry point with the County Department of Human Services. Number 3, this we rarely have any discussion about. By the time people are looking into the long-term care versions of Medicaid, you kind of already know that there's a medical necessity test. To get the forms of Medicaid that we're talking about, you have to have the medical necessity for requiring the level of care provided by a skilled nursing facility, which we might shorten down to SNF. So, or the nursing home. So you need to have the oversight provided by a skilled nursing facility, and that's called the medical necessity test. And the way that the state determines whether or not you have the medical necessity for a skilled nursing facility is they've developed this instrument called the LTC 100, and it goes over a series of questions, and it heavily weighs cognitive impairments. So what there is so there's like a point system, and so your points got to be like 4 out of 6 in certain areas, but there's a point system. Once you hit that point, that's when they've determined you need the level of care provided. This is usually not an issue. I mean, I will tell you 90% of the cases I see are probably dementia, and those are very easy to screen for. They're going to hit, a 4 out of 6 on the cognitive portion of the LTC 100, or if you need physical impairment, so typically we don't spend a lot of time dealing with medical necessity issues. You should just be aware you have to meet the level of care provided, and if you do, then you go to the next 2 issues, which we're going to spend all of our time on. Because these are the 2 issues that come up as a practical matter, and these are the ones that need solutions. The next big issue is, what's our income? Preliminarily, your income needs to be, give or take, and I did not update the figures for today, so this is a real ballpark. It's about $2,200, or it might be $2,290. So to be the Medicaid applicant, yes.
Per month?
Yes.
I'm sorry, okay.
Yeah. So we're looking at a monthly income, and for the single applicant, we're concerned the income has to, well, it doesn't have to be, but we'll talk about this. We're looking at the income to be below, I think it's $2,290. Good guess, it's in that ballpark. And if the income's below 2290, you meet the income threshold requirement. If you go over that, we're going to talk about it. It's not a problem, it's simply another detail, a little more work, and a little bit of administration, but we can get over that. But we're looking for 2290 or so or less. The final thing, and this is where we spend most of our time, is we look at assets. With respect to Medicaid, go back to point number 1, which we made. It is means tested, fancy word for welfare. It's means tested, so we have to describe what our assets are. So we want to know what your assets are. Your assets are going to divide into a T-bar into one of these two worlds. It's either this or this. It's either going to be a countable resource or it's going to be a non-countable, otherwise exempt resource. So we want to know what your entire property is, anything you have of value, intangibles, everything. So everything goes into a big old pie, and then we start putting it into, well, do we have to count that because we have limitations on your countable resources, or is it exempt? So let's talk about the exemptions. The exemptions that everybody gets are the homestead exemption. So a lot of you, because you work for lawyers, and lawyers are bad and they sue and they garnish, you're probably vaguely aware that Colorado has a homestead exemption. And you're aware that we have a dual homestead exemption, unconstitutional, I think, because I'm less than old and I'm not documented disabled. So there's 105 if you're labeled elderly or disabled, 105. So that's why, you know, I'm bitter because I know I don't look, I'm under 60, just so you know. So I can't claim the elderly. I am disabled, it's undocumented, and I don't get paid. So I can't claim that one. I get the one that everybody gets, which is 75,000. But for Medicaid purposes, so remember, just in Medicaid world, this is all this applies to. The homestead exemption is over $500,000. So you can have a primary residence with a net equity of, I believe it's 530 or it's 540. It's five and change, and that's going to be okay. It's more if you're married, by the way. So in a married couple, this is one of the times when there's a distinction. A single person's capped at five and change, and I'm going to go 530. That's the number one exemption we deal with. The home is exempt, so we're not going to count it. So we're good to go. Our next best exemption is typically the vehicle. I'm going to tell you what I've actually done. This works every time. You are entitled to one vehicle of any value. Did I say any value? I said any value. Now, once again, for those of you that sue and do collection work, and you know that there's a vehicle exemption for general creditors of $7,500 and $12,500 for the elderly disabled. For Medicaid purposes, the exemption is with respect to the vehicle, and its limitation is one. You get one vehicle of any value. Have I had the person buy a $50,000 car and I've told the Department of Human Services and they approved that application? Yep. Why is that? I get a vehicle of any value. It has to be used or necessary to go to and from necessary doctor's appointments. That's it. That's easy to make. And if you can't drive, is this a problem? Never. Well, I can't drive, but Billy, my cousin, does, or my lovely daughter, or my daughter-in-law. Somebody can take me, and that's going to be enough to get the justification. You don't even have to show it. All you got to do is throw out one vehicle, and you're good to go. So these are some of our best exemptions. Yes.
Sorry. So does the vehicle have to be just in that individual's name, or can it be joint with the spouse?
The question was, does the vehicle have to be joint in that person's name, or can it be jointly titled with the spouse? That is an excellent question. Again, the Department of Human Services, they have their weirdness. One thing is you can have like a $90,000 Porsche Cayenne exempt because it's only one vehicle. Does it have to be solely in the Medicaid applicant's name? It does. It does. Now, funnily enough, and we're going to talk about this when we compare and contrast the married applicant, the married couple. Each married person is entitled to a car of any value that he or she uses solely for his purposes. So in a case with a husband, with a spouse, we can have another vehicle of any value, but once again, that vehicle needs to be titled in that spouse's name. So we can have two vehicles worth $1 billion, but they have to be titled in one in the Medicaid recipient's name and one in the community spouse's name. And the community spouse is the one we refer to as the one who's not getting Medicaid. The community spouse is the one that's in the community not seeking services. We sometimes talk about the Medicaid spouse, the Medicaid recipient, or the applicant, and that's what we're talking about. Next, this is one to look for because you hit this a lot in this town still. It used to be, every other case had a uranium claim. And so you're all, I mean, y'all been here long enough, you know about the uranium money. Uranium money, this is a surprise every time. Even to the Department of Human Services, when you have a change in the eligibility technicians, you know, they have literally 8 people who are assigned by the alphabet, and they'll switch it up. You have to tell them these regulations almost every time. There is an unlimited exemption with respect to uranium proceeds. There's 2 pots of money you could hit. You could have $225,000 because you got the original one and then you got the upwind one, if you all recall that. If you've been here long enough, you know they have like the first settlement could be like 150, the second one could be another 75, you can get 225, I think. That money can all be exempt. There's only one tiny, tiny little kicker, and it's almost always an issue, tracing. You cannot commingle, and you have to trace the money, and you have to show at every phase you've had the money. There's never, ever, ever, ever been commingling. Everybody knows what commingling is, right? Right. If you got commingling, you've got a problem. It's very difficult to trace the money, and once you have it commingled, the department has a almost knee-jerk reaction that, you know, that money's no longer exempt. It was mixed with the non-exempt money, it's not exempt. Might they be right? It doesn't matter because it would take so long to resolve it at a hearing. You just simply need to make sure you can trace the money and show it's never been commingled. If that's the case, that exemption comes up more often than I can even believe, but it comes up. The next one is the funeral plan. In Colorado, we have an unlimited exemption for a funeral plan or burial plan. So you know when you die, but when you die, you can prepay for these things, and as long as you do it right, that plan, whatever's in there, is 100% exempt regardless of the amount. Have I had $50,000 funeral plans? I have. I know. It's shocking. And here's why, because they can prepay for all this stuff, like you got a big family, they can prepay it so that it's all included in the cost. You're flying people from out of state here, you're doing all this stuff, you can have a bunch of money in a funeral plan. And so long as it meets these couple of requirements, it's exempt. Requirement number 1 has to be irrevocable. Cannot undo that funeral plan. So it has to be irrevocable, you cannot get the money back. Requirement number 2 is, and I did this planning, so I'm going to tell you what we used to do. Knowing that there's an unlimited exemption for the funeral plan, what are you inclined to do? Throw a bunch of money in there, and what are you inclined to do? Pay for a $3,000 funeral, right? So you both throw, you know, $8, $9, $10, $12,000 in there, and you tell the client in advance, it's exempt. When you don't spend all the money, get it back. That was legitimate. That was legitimate prior to 2005. That little loophole's been closed. It was 2000 and something. Was it 2005 or 2001? I don't know, but that loophole was closed. So now the next requirement is, in addition to irrevocability, if there are unspent proceeds, where do they have to go? They have to go to the Colorado Department of Healthcare Policy and Filing, or Policy and Finance, HIPAA. So those are the folks that administer the monies for the Medicaid program. And HIPAA has to be the payee of any unspent policies on your pre-need policy, your burial plan. So they got rid of the loophole, but still you can put money there. And still, if you know what you're doing, you can extract some benefit from that by, you know, paying for such things as, well, the funeral's going to be in fill in the blank. Well, Mom was from Kansas. I wouldn't have the funeral in Kansas, but she wanted to be buried in California once Neptune Society. Pay for it. So there's still some things you can do to tweak it a little bit. Just, you know, with Medicaid stuff, remember, you're only going to be at the local level unless you do something that causes a review. And so you want your eligibility technician to have no reason to go to the state. So pigs and hogs, one gets fed, one gets slaughtered. So just remember that too with Medicaid planning. The next, there's also, you get your household goods. Your household goods, the exemption for your household goods, real low. Good news, they don't check, and also they don't really take the view that even if you have antiques, I have people say, oh, I have my China hutch from my great-grand, nobody cares. We value the household goods at yard sale value, it's never an issue. If you have an item of what I would call particular or unique value, that would be something you want to bring up. But otherwise, anything in your house, nobody cares. There are exceptions, of course. Cash on hand, coin collections, metals. By metals, you know, I mean, you know, metals, gold, silver, whatever. We're concerned about that kind of stuff. The other exemption we have that we use, but you can never, this one is only gonna get it, the property through the process, it's, you can't really go buy it. But I've had people say, can I go buy a new wedding ring? You can't. Can you have a wedding ring of any value though? You can't. And I've had the $50,000 wedding ring. Stupid, but they had it, and it was an heirloom, and it was huge, like, you know, the kind that they thought it was cubic zirconia, but it's not. It's perfect. That's a $30,000 to $50,000 rock because of the clarity. That rock is exempt as long as you didn't buy it. Now, can I, as part of my process, like you had the gold ring, and you've been married for 50 years, and you know Harold wants to buy you a new ring with a $50,000 diamond? That's not going to fly. We can't do that. But if Harold gave you the $50,000 diamond, we're good. That sucker's coming right on through. Medicaid never touches it. Okay, so those are some of the basic overviews of the most common exemptions. Let's talk about the husband and wife scenario because we have some better planning options. With a husband and wife, let's talk about the differences. Unless you have questions about the single person, very, very brief overview of Medicaid. If you don't have questions, we're going to go to his husband and spouse. Spouse and spouse.
Well, okay, I do have a question to clarify. So this person can have a $500,000 home and a $30,000 vehicle and.
Unlimited value on the vehicle.
Right.
Unlimited value.
But I can't, so, and then they need long-term care so they can get Medicaid to pay for it and they never have to pay back.
We're going to talk about recovery. There is such a function as a state recovery. And I get people saying all the time, well, there's going to be a lien. There's going to be a lien. There's not. There might be recovery, and we'll talk about that. So I was going to talk about recovery after we've talked about the compare and contrast between the single person, which we've covered, and now if we move on to the spouse situation, then we'll talk about recovery and ways to avoid recovery, because that's sort of what we try to do. So I'll answer that question when we get to that.
Okay.
But that's a good question. Let's go over quickly the spousal situation. So you got a community spouse and a Medicaid spouse. So the Medicaid spouse, they can't have $2,000. They can have up to $2,000 actually, but I tell everybody they can't have $2,000 because then you go over $2,000 and you're ineligible. The Medicaid recipient cannot have $2,000 in countable resources. Okay, that means they cannot have cash on hand. They can't, you know, they can have a personal needs allowance. And I tell people safely, keep it at $1,500 because then we don't go over the $2,000. And once you're on Medicaid, by the way, there's annual continuing reviews. They're called CDRs. It's a continuing determination of some sort. But anyway, you never want that person to go over $2,000 on the first of the month. Income's different before you say, well, if they have $1,500, they get their $2,000 check. Don't they have one? They do, but income is counted and considered income the month received. So it's not a resource until the following month. So the big takeaway is Medicaid recipient ought not have $2,000 and keep a little below. Now, the community spouse, how much can they have? Well, Colorado actually is the best, one of the best states, because there is a range. There's like the federal max, there's the federal minimums and the federal maximums. On this one, we're at the maximum, so it's surprising. There is a maximum, one is called community spousal resource allowance, that the community spouse, the one not needing the nursing benefit, they can have liquid cash on hand of up to 123 grand. So they can have 123 grand in non-exempt resources, and we're mostly going to be looking at cash. And that's good. We can exempt that amount because that's what they get is that allowance. So they get a cash allowance of up to 123. Does it have to be in the community spouse's name? Absolutely, it has to be in the community spouse's name. Go back to rule number 1. Medicaid recipient cannot have $2,000. So it's all got to be in that community spouse's name. This gets to be an issue when you've got retirement accounts. The retirement accounts are in the Medicaid recipient's name. Those got to be moved over, however they can be moved over to the community spouse. And if that means liquidating it, taking a tax hit, liquidate it, take a tax hit, and put the money over here. In fact, I oftentimes think it's better to do that because your payment of your taxes is actually going to be a legitimate bona fide spend down. But so if you have a spousal situation, the community spouse can shield the 123,000, which is one of our best exemptions. The other differences are the community spouse's income does not count. So we talked about the Medicaid recipient, it's 2,200 or 2,290, that's the ballpark. And so we are concerned about the Medicaid recipient's income. Are we concerned about the community spouse's income? No. I've had the person who's a retired superintendent, and she was a community spouse. She got $7,800 a month. No. Didn't make an ounce of difference. Husband did not get any $7,800 a month. He was the one who was a community spouse. I'm sorry, Medicaid spouse. She got her income, happily got that income, no restrictions on her income. Now, there is a way to spend it down if you have excess resources. If you have a community spouse and that spouse's income is less than $3,200 a month, that community spouse can take resources, convert it into an annuity, and so long as the monthly income for the community spouse does not exceed, I think, $3,200, we're good to go. And that gives us a place to dump money if we're in a situation, which you are, I would say a lot, not every time, but frequently you have people that, they have more liquid resources so that they're over that 123 limit. This is, of course, the spousal situation. So you want to see how you can improve the life of the community spouse. What's one of the best ways? Well, that's income. They can buy an annuity, and as long as the income as long as the annuity is actuarially sound, meaning it's based on their life expectancy actuarially, even if they're going to die tomorrow, it doesn't matter. As long as that annuity is actuarially sound, meaning based on actual life expectancy, and as long as it pays in substantially equal installments, meaning you can't have this large balloon payout 10 years down the road, it's got to be paid in substantially equal installments. And so long as you leave the Colorado Department of Healthcare Policy and Financing as the payroll on death beneficiary, if there is going to be a lump sum left over, you're good to go, and it's a nice place to consider looking, because I should have talked about the Medicaid recipient's income. So let's talk about that now so you can see why this is a good idea. So I'm on Medicaid and I'm going in. Stupidly, I remarried, and now I have a spouse. So my spouse no longer will get my income. So I have to pay, my income is going to go like this. If I'm a single person, I get the first, well, it depends if I'm in assisted living or skilled nursing. I'm still okay, so it would probably be assisted living. So if I'm in assisted living, I get the first $118, I think it's $118 to $121. And that's my personal needs allowance. Where's the rest of my income going? To the facility of residence as the patient payment fee. So I get to get my personal needs allowance, and it's going to depend. And then everything else is paid to the facility of residence, and then Medicaid comes in and they pay the balance up to the capitated rate that they've negotiated. So for assisted living, I think they pay like $26 or whatever. So I pay towards it, they come in, plus I get my Medicaid card. And so I'm getting my 116, the facility is getting the balance of my money, and so I got no money. So if I have a spouse, by the way, now I have a spouse who is entitled to support based on the income. And so the way it is if that person has less than $2,000 a month in income, my income can be used to supplement that up to that level of $2,000. We count all income from that person, but to the extent that it falls below $2,000, you can supplement it with my income, right? You can't. So that's another little bypassing. That's called the minimum income allowance. And so we want to look at that to see, am I going to get the minimum income allowance? Is that enough to meet my needs? Let's assume it's not enough to meet my needs and I have extra cash. I can then go in and purchase an annuity, take that person's income up to the $3,300. Do they get my income? They don't. My income's going over here, but it doesn't matter because now they have $3+ grand a month, and that's going to be guaranteed for their actual life expectancy, which is a pretty good result. So this is why we look at annuity planning with Medicaid. We look at the community spouse to see what are that person's needs going to be. And we look at the alternatives of, well, now person's going to facility, you're losing that income. Yes, we can get you up to $2 grand a month, but is that enough to actually meet your needs? If no, let's look at the annuity option. And then their life even gets better because when I die, now they get my Social Security. Wow, that's a really good thing. But that's kind of what we look at for the annuity. I'm trying to think, the only other major difference is with a husband and wife, you can get more in terms of household goods. Once again, we've already been over household goods, no big deal. The only other thing is now we got the 2 vehicles, and so, what's my dream car? I don't know. maybe it's a Beamer, so I go get my $55,000 vehicle. But now I can have a Beamer and the person I marry, probably not, can have, let's say, a Mercedes. That's good. So that's pretty much the only differences between his and her plan. So are there questions yet? Okay. If there's no questions, we're gonna go on to, now we've gotten Medicaid, we're good to go. Yes,
What about the household, the house? Did you mention that with husband and wife?
no,
What the value of that?
that's good. Let's talk about the house. That was a good question because we had the vehicle question, which was also a good question. The house, we don't care if we're Medicaid, if the house is titled in one spouse's name or both spouses' name or the Medicaid recipient's name. It's good to go. The stock standard advice that I give to people is you want the house in the community spouse's name because this is going to provide for the best chance you're going to have to avoid what's called estate recovery, which is the topic that we're going to talk about. We're going to talk about estate recovery, and then we're going to talk about it in the context of the single Medicaid applicant, then we're going to talk about husband and wife or spouses.
So what's the homestead allowance right now?
It's $1 million. My recollection is it's double whatever it is for the single person. So the single got like 5 and change, so the married one is really good. So I think it's $1 million, but I'd have to double check that, and that's something I'll do and I'll update Robbie. It's either $1 million or there is no allowance for a husband and wife. So it's enhanced, it's more than the 530, that's the recollection. But it's either double or it's unlimited in that. But I'll check on that and I'll make sure that I get Robbie that information. So if I'm single and I am on Medicaid, the home is not a countable resource. Does that mean my heirs get the home? Yes, after payment of the estate recovery claim. So the state of Colorado, while they exempt certain property, do they want to be paid back? Yeah, because remember, what is this we're talking about? It is you don't have a right to Medicaid. You do not have a right to Medicaid. It's means tested as welfare. We want to be paid back to the extent that the state has paid out for you, and we want to recover. So while we're good with you having a homestead because you can live in it, and then when you can't live in it, we're good with you having it, giving you Medicaid. When you die, we want to be one of your creditors in your probate, and we want to file a claim that recovers to the penny what's been expended for the Medicaid paid on behalf of that individual. And what is the average claim? Any guesses? And I'm going to tell you, I did not put pen to paper to run this down. I'm just going to tell you anecdotally based on what I see, what the average Medicaid claim is that I see. That means there's claims way in excess of this and claims way less than this. If you want to take a crack at the average, go ahead. How much? 200?
Million.
Oh, no.
20,000.
No.
30,000.
No, 150. If I had to tell you anecdotally, all the claims I've seen a lot. If I just had to say, here's the average of all the claims, it's about 150. So this is significant big money. And it can be more than 150. Like I said, this is an average, you know. I mean, do we have the $300,000, $400,000, $500,000 claims? Oh, we bet we do. We've had some people getting to 106. Mabel, that Mabel's claim was it 380? It was huge. But yeah, I mean, she was 104, 106 when she died. So she was in nursing home for a long time. So I'm surprised it wasn't even more. But so 150 is what I would say we're looking at. So as you can see, a Medicaid claim for estate recovery is going to wipe us out. So there are ways around that, but you should just be aware the best ways for getting around the recovery claims are in the spousal situation, not the single person. You can get around it with a single person. It's doable. Totally doable. It's harder, requires planning and such. Yeah.
Here's my, going back to Mabel. So Mabel is married, she outlives her spouse,
Oh, God, yeah.
and then,
106.
well, yeah. And so does that mean that then her requirements change upon his death? You know, yeah, from married to single. Does
Yes.
that- Okay.
Yes.
Okay.
When you have a spousal situation and you have a Medicaid recipient and the community spouse, and the community spouse is the first to die, everybody here is aware generally of your rights of spousal election, right? You know your spouse can't totally screw you. They can, they're smart, know how to do it. But the rule is, the rules are that you can generally, as a spouse, elect against your other spouse's will if you're the survivor saying, I wasn't supposed to be disinherited. That was not supposed to happen. And so you're aware generally of spousal election, right? You know that when that comes in, and you know that, hey, even though you were disinherited, you have these rights, you got timeliness to exercise the rights, but you know about that. So does the state of Colorado. And so the rules in Medicaid require that when a community spouse dies, the Medicaid spouse has to get whatever that spouse would have got if that spouse filed a timely election, meaning in a probate, saying, I want my elective share, which is up to 50% based on length of marriage and all this other crap factored into it. So they're supposed to get that, right? So the Department of Human Services has a rule that says if the Medicaid spouse doesn't get that from the community spouse's estate, we are going to penalize the Medicaid spouse by what? What is the big penalty? We're dropping Medicaid, ain't gonna be no Medicaid, what are you gonna do now? There's a couple practical things we can talk about, and this is what you really do, but that's the rule, so you have to plan around it. So what happens is, by the time somebody's in there, like let's say Mabel died, husband, I do remember husband's name, Norman was long gone. Norman died like long before Mabel. I mean, he died in his 90s, So he died, and here's Mabel. So Norman naturally, and I don't know that this happened, by the way, I was involved afterwards, but he naturally, let's say he's got his $123,000, right? Because that's the community spousal resource allowance. Naturally, what does Norman want to do? Norman wants it to go to the kids. So what does Norman do? He does all this POD crap, and the kids get it. Well, that is not going to avoid the application of the rule, because as you know, if Mabel were with the program, she could file a probate, she can use the clawback powers, get that money in there, get her elective share, and get out. The rules require that the same result that would obtain, and that Mabel get her elective share that she would be entitled to if the probate were filed and she exercised it. And if you don't do that, there is a penalty, right? Right. Now, this is the real practical matter that you can't really say out loud. But if you have a case where the kids are horrid, or they're of a different marriage, Colorado is still one of the better states for this, and that is application of the hardship rule. Because you're going to have people that come in, they've done bad things, they've done stupid things, they thought they were doing something clever, and it wasn't. This is one of those clever things. Well, Dad put me on the account, and when Dad died, I took the money, and I'm not paying it over. Okay. You might be able to get a hardship on that, especially if Mabel is, really bad off, demented, not with the program. And so probably that's going to work. But dead to rights, the rule requires that Mabel get her share. We take Mabel off of Medicaid, she spend that down, and then she goes back on Medicaid if she's still alive. So that was a good question. Yes?
Can a married couple, if one is in a nursing home and the other is the community spouse, can that community spouse set up a special needs trust for
Yes.
the person in the nursing home?
Yes.
Okay.
That's another thing they can do. The use of special needs trust is authorized. You can do it. It's going to have a problem because you're still going to have a clawback provision where the Department of Healthcare Policy and Financing, under that scenario, would likely, you might get something where they have to be paid. We would look at that as an issue. Typically, what we're going to do, though, is we're going to do other planning modes, and we're going to talk about the house. Very oftentimes, we can protect the house, even under the scenario where the community spouse is the first to die. I'm going to go with a very simple little trick. And that trick is, first of all, if you have a spousal situation, in whose name do we want the house? I've already told you the rule is for Medicaid purposes, we can have it in the Medicaid applicant's name, we can have it in the community spouse's name, we can have it held jointly. Which way do we want it? This is so true. And the answer was community spouse. That is the absolute 100% answer. Now, can we transfer the home from the Medicaid recipient to solely the community spouse without a penalty? The answer is we can, absolutely. Transfers between spouses do not trigger any penalties, which reminds me, we have to talk about penalties, because we didn't talk about that yet. And that's a really good topic, and we're gonna talk about penalties. And I should have talked about that before in the eligibility part, but you know what? We don't have all that time, so I want to get as much information out there. So we want the house to be in the community spouse's name. And we want it to be in the community spouse's name because we want to trigger a probate. Only if the community spouse is the first to die. For those of you that do any amount of estate planning, I'm sure that you're aware that there are beneficiary deeds, right? So you work with beneficiary deeds, you know that they're like a real estate POD, payable on death, and they can be good. I personally don't think they're good if there's more than 2 children, but they can be good and very useful. You can use it for a lot of things. I forgot to tell you, the homestead exemption only applies if the property is owned by either the Medicaid recipient, the community spouse, or the parties jointly. If it is in a living trust, guess what? No exemption. You do not get an exemption. So the house has to be owned individually. If there is a beneficiary deed that has been recorded, no exemption. The house is now treated as a countable resource, and now you have to deal with your 123 grand, which is your community spousal resource allowance. And so the house has to be owned in the party's name or one of the parties' names. So the one we want is the community spouse. So now that you know that you can't have it in the trust and you can't have a beneficiary deed, we know what the state's trying to do, right? The state's trying to force probate. So if the community, let's not do that one. Let's do, if the Medicaid recipient is the first to die and the community spouse is a survivor, do you know what the recovery is? 0. We don't have a lien, we have no recovery. If the community spouse is a survivor and the Medicaid spouse is the first to die, we're good to go. We are good to go. There is nothing owed. There is no estate recovery. We're good to go. They used to have real life liens. You haven't seen one of those in forever, but the lien's abolished if the person dies or if they go off of Medicaid, which is another nice little trick. But if the Medicaid recipient is first to die, we have no estate recovery, we have no lien. We're moving on down the road, and the surviving community spouse can do with the property whatever they want. They can give it away, change their will. The state does not give anything back. Now, if the community spouse is the first to die and the Medicaid recipient is alive, what do we have to do? We are required to probate. Why? Because the state wants to make sure, and they will find this out, by the way. I don't know how they find it out, they do. And they're going to say, if you don't seek to probate this estate, we're going to seek to probate this estate. They'll send out a letter to that very effect. And so what you're going to do is, you now know that, you know, if you're planning conservatively, plan for the person that's not in the nursing home that's going to die. And if that person dies, what are we going to do? How are we going to protect the house? Because we, generally speaking, have a very good chance of protecting the entirety of the house from ever having a recovery. And here's how we're going to do it. So you know these couple of rules going in. One, community spouse, or I'm sorry, Medicaid spouse has to get whatever the elective share would have been if they would have filed it and been disinherited. So we got to pay them 50% of the estate, right? Depending on length of marriage, 50% of the estate. 2, you also know that they only get 50%, and this is a good thing. The home is also going to continue being exempt, even if it was in the community spouse's name. Even upon death, the Medicaid spouse can still claim the homestead exemption in the home. So the fact that the home was entitled in his or her name doesn't make any difference. The homestead exemption applied. That exemption doesn't go anywhere, and it doesn't change based on the titling of the property, because we can have intra-spousal transfers. So here's what you do. You make a specific gift of the house in the will. You give 50% to community spouse, because that keeps us within the reg. And then you give the other 50% amongst the children that you would do in the various percentages. So let's say you have a typical two kids, so husband and wife, they've been married their whole lives. That's, you know, possible. And then they have 2 children, and the children's name are Lori and Chris. So you say, hey, I leave my estate, I make it specific as my real property, 50% to my wife, and then 25% to Lori, 25% to Chris. all as joint tenants with rights of survivorship. And that PRD reflects that very thing. I'm making a specific portion of a gift as a joint tenant with right of survivorship. And now I've satisfied the regulation, right? Right, I have. I've totally satisfied the regulation. She's gotten 50% of the estate. But I've also avoided estate recovery, assuming the children outlive the mother, right? So, and that happens, I mean, it happens where they don't, but I mean, normally you're gonna assume that the children will live, right? So mom dies, now by operation of law, property transfers to the children, voila, operation of law means no probate. No probate, no way for the state recovery, the state's recovery unit to file a claim, we're not going to pay them back. So that's how we look at real property. Real property is typically, for most people, by the time they're looking at Medicaid, the real property and the home is like the big ticket item. And that's what we're most concerned about transferring. Might we have to spend down like money for mom if we have cash on hand? Yes, because mom has to have 50% of anything left over. So if we have cash that's left over, yes, we need 50% of that to go to mom. We spend it down. There's all sorts of tricks to that. And then mom will once again be qualified for Medicaid and we're good to go. And we've saved the big ticket item, which is the house. Yeah.
Question, all of this has to be done like 5 years prior to them getting on Medicaid?
No, absolutely none of this has to be done prior to them getting on Medicaid. Everything we've talked about is stuff you can do right now. Because remember, we've only talked about intra-spousal transfers. There is no penalty for intra-spousal transfers between spouses. No penalty.
That spouse is not single.
Right, and we're going to talk about the single person, and we're also going to talk about transfers and penalty periods, because I realize that's a conversation we should have had more near the front and not quite on the end, but we're going to cover it before we're done. So that's a good question, and we're literally going to talk about it right now, unless there's another question before leaving this topic. No, okay. Let's go back to eligibility, and I forgot to talk about things that cause problems. And it's one of the things I used to hear all the time. Well, I have to wait, 8 years, 9 years, 3 years, 5 years. People have a general understanding that there are penalties for transferring property before filing for Medicaid. First of all, we've already covered there is no penalty for intra-spousal transfers. We can transfer back between one another whenever, no penalty, we're good. When do we get penalties? We get penalties when we give to people outside of the spouses, namely children, right? Because they're the ones that are always here trying to get something for us for nothing, like they haven't already gotten enough. So they're always the ones looking for things, and mom or dad are like, well, I would rather have them get it than the state get it. We've already covered that. The state's not getting anything. So when you're looking at Medicaid, the proper look back, there used to be varying look backs, but not since 2006. Now we have one look back, it's 5 years, and it's 5 years we're looking back for any transfers to any third parties that were gifts, meaning a transfer lacking consideration. So if you're trying to do a gifting strategy for Medicaid, you can still do it. It has some stuff that we're not going to get into. You can do it, but let's go back to the transfer. You have a penalty period of, or you have a look back of 5 years. So any transfers that you have made 5 years before date of application have to be disclosed. So when you put that transfer out there, whether it's a disqualifying transfer or not, we're going to talk about it, yes. Yes. No, beneficiary deed doesn't count. The question was, does a transfer include a beneficiary deed? And I said yes. I said yes because it's a problem, you can't do it. But does it count? No, it does not count as a transfer because on the face of it, a beneficiary deed is not a completed gift until the event, which is you're dead. So there is no completed gift. So does it count as a transfer? It does not. What's the problem with the beneficiary deed? If you do a beneficiary deed 5 years before applying for Medicaid, you've now rendered the homestead accountable. What's the problem? Now instead of getting the homestead doing no planning, now we have to put it in the accountable column and we're not going to qualify. And they're going to deny you that Medicaid application because they're going to say you have non-exempt accountable resources, meaning you have over $2,000. So that's the problem with the beneficiary. So when I said yes, I meant yes, that's a problem, but no, it's not a transfer. Absolutely, you can revoke a beneficiary deed at any time except for when you're dead. So you can revoke it prior to death. So what you do in a typical case is, if you have a recorded beneficiary deed, you have to record the revocation of it. That takes that away, and then once you claim the homestead exemption, which is one of our very best exemptions under Colorado law for Medicaid purposes. So let's talk about the typical transfers that we're going to run afoul of. The typical one is the children, and for the love of, I don't even know why people want their children now. It's like, have they got enough? But no, you get it, and also you especially get it when the child is there in the employment. Well, wouldn't it make sense for mom and dad to put so and so in my name? No, there wouldn't. You know, it makes sense for you for them to put it in your name. It doesn't make sense for them to put it in your name. Or, well, mom and dad put that in my name, and it was because of, long, complicated story, which boils down to the same thing. I wanted it, and, I talked them into it, and they said, okay, I get it. You want to enrich yourself. You don't want to pay for mom's long-term care. I know this because people are basically greedy, but that's a problem. So you can do gifting to children. But it has to be done with the notion of either you're going to have the 5 years, or if you transfer within 5 years, you're going to have a Medicaid penalty. How do we calculate the Medicaid penalty? We calculate the Medicaid penalty thusly. We take the amount of the gift, and then we divide it by the amount that has been determined to be the average amount for skilled nursing care in this region of Colorado, not in all of Colorado. Colorado's divided into like 19 regions. We're region, I think we're 4, but I don't know. But you take that amount and divide it, and then that yields a period of time, and you can fractionalize the time, and you can have days and within months. And then that's going to be the period of time when we're not going to give you Medicaid. You are not getting Medicaid. So you apply, and then you calculate the penalty period. After the period's run, then you're eligible for Medicaid, and that was the question.
How do you determine the amount? Do you use the assessed value or the property value?
Let me repeat the question, and then I'm gonna tell you what the penalty divisor is, then I'm gonna answer your question. And the question is excellent, by the way. The question was, how do you determine the amount of the penalty if it's your home? Do you use the assessed value? Here's the answer. You use the lowest value you can justify. If the assessed value is in, you hang your hat on the assessed value. If you get a CMA and the CMA is lower than the assessed value, you use that CMA. If you have an appraisal that's even less, you use that. Answer, you use the lowest value possible, with the assessed value being one of the available, very accepted methods of valuation. There is a statute that specifically says they have to accept the assessed value. And as we know, in Mason County, the assessed value has been under market at various periods of time, like this. So you can use the assessed value, but the answer is use the lowest one possible. If you use the assessed value, you could just refer to that in the application. If you use a value less than that, you want to include that with your original application. So that was an excellent question. Let's turn to the penalty. The penalty per month is, the penalty divisor is the amount for skilled nursing care in this region of Colorado. I'm going to just ballpark it. This is a ballpark. Do I look this up sometimes? I do. Do I update this? I do. As we sit here, I can't recall what it is, so I'm going to tell you a recollection is about 7,400. So I'm going to go with, well, just for purposes of today, just go with it 7,400. It's $7,000 plus, I'm going to tell you, but let's just say it's 7,400. So to give a really easy application penalty, let's say that I have $74,000 and I give it away. And I give it away to an adult child. What is my penalty? 7 months. Because you take the 74 grand, divide by that $7,400 figure, that's a 97 months. And so now I will not get Medicaid for 7 months because I've made that transfer. So my plan has to be, okay, even if I'm applying now, I know I won't get it here, so I'm going to have a plan for that. That's how we do the penalty. Now, for valuation purposes, if my gift was in the form of some share of ownership interest in the home, we would use the assessed value to determine that. Now, there's some real funny stuff you have to understand about doing transfers in the home. A lot of people, we used to do this, by the way, it used to fly. You used to see a lot of deeds, and I'm sure if you've done any title work, you've seen it. If you go back to the 90s, you would see it in Mason County. You'll see these stupid deeds that say, my name is so-and-so, and I'm deeding the property, I'm doing a deed, to me and my adult child, wherein I have a 99% unrestricted undivided share. Adult child has a 1% unrestricted undivided share, and we're doing this as joint tenants with right to survivorship. Why am I doing that? Because I want the kid to get the house when I grow, and I'm looking at Medicaid, right? I'm looking at Medicaid, and I know that if I have a probate, they get paid back, and joint tenancy creates the ownership is by operation of law upon death, right? Right. I record my death certificate, kid owns the property free and clear, they just got 99% of the home, and now they have a one undivided 100%. That is cool, right? Because let's say my home is worth 100 grand, so my 1% gift would only be $1,000, and gosh, that seems too good to be true, doesn't it? Since, give or take, 2000 and something, 2001 to 2004, it is now no longer acceptable, it is too good to be true. And then you're gonna come back and say, you just told us we could do it in this context. That's different. In the context of pre-Medicaid application, we're gonna make a gift, none of that flies. There's only two ways to determine the percentage on the Medicaid, for purpose of the Medicaid application of any gifts. Let's say I put my kid on title and I try that 1% trick. How is the department going to assess the penalty? The answer is they're going to assess the penalty as a 50% of fair market value penalty. So my property is worth 100 grand because I told you that. They're going to say 50 grand and they're going to do a penalty period based on 50 grand. And they're going to do that because their regulations specifically provide that they can disregard that kind of trick and they can just go with the number of people on the title and they're just going to allocate it based on that percentage. So that's what they're going to do. That's going to happen. So I can do that little trick. It's going to still get a penalty. There may be tax reasons for doing the trick. There might be tax reasons for doing that trick, but for Medicaid planning reasons, there's no reason to do the trick. The transfer to the kid is going to be assessed at 50% penalty. So I take my 50 grand, divide by my 7,400. That yields a series of months, the fractionalized portion. That's my Medicaid penalty. So that doesn't work. You cannot do that little trick anymore. Okay. Do you have a question?
So if I did this 4.5 years ago and did the 99 and 1 or whatever it is, do they look at the value when I did it 4.5 years ago or the current value?
Current.
Because 4.5 years ago, assessed value was less than now, supposedly.
That's a good argument. As a practical matter, they're going to look at the current value.
Gotcha.
What I absolutely put in there, here's the value. I would put in here's the value. They'll probably look at the current value. That would be probably something you could window by just saying, no, this is the date of the gift. You value it as of that date. And you can even analogize it by saying, if I gave them 10 grand, we wouldn't be talking about the value. We'd be talking about what I gave them. So that's a better argument. They normally will pull the current assessed value. Okay. But you're right. They should actually look at the value back then. That was a good question.
When you call it transfer, like transfer half of my property to a child, would that, or doesn't necessarily have to be a family member? Would that be a quitclaim deed? What does transfer mean? What paperwork?
The quitclaim deed is an example of a conveyance, which is an example of a transfer. The paperwork is going to depend. Typically, you can very easily do a quitclaim deed. That's not a problem. If they have title insurance on it, I think the conventional wisdom is you want to do a warranty deed because you want to preserve that title insurance in case any claims became the colored title. The title company is going to disavow any responsibility saying you quitclaim, so now we don't any longer have to insure it. So you would do either a quitclaim or you do a warranty deed if you had a concern. But yeah, you do a conveyance of one of those sorts.
But if there's a quitclaim deed adding or transferring the property, Medicaid still does the look back and then 50% penalty on the assessed value.
Well, it depends on the number of transferees, but yes, that's the gist. So Medicaid's going to look at if that date of application of Medicaid is within 5 years or less of the date of the transfer, they're going to go back and they're going to look at the number of transferees. They're going to look at the percentage on the deed. You can actually have varying amounts for interest for the transferees, by the way. I mean, I told you what the rule is. If you're gifting the property, we're going to use the rule of how many people are on it. That's going to be the amount of the gift. There's also other very complicated things you can do, including the retention of life estates. which I'm not gonna get into. I'm just gonna make you aware of there's other things we can do. Like we can transfer the property and keep what we call a life estate. So there's other ways of doing it other than my example. But we don't have all the time, and I just wanted you to kind of get the gist of it so that you knew there would be issues to look at further. But the answer is they look at the number of transferees and go back, and they should use the assessed value. They won't. You have to argue the assessed value on the date of the transfer, not on the current. But they should take that value, I think. And that was another good question. So I was going to kind of wrap it up after now, but we have also more than enough time if there's any other questions.
Did you have a question?
No, I think I got it.
Okay.
I think.
All right. What I'm going to do is I'm going to follow up with Robbie on one thing, and that is going to be the value of the homestead exemption for married couple. And so hopefully you'll shoot out to all of you and say, okay, well, there's the answer. But otherwise, that was like a very brief overview of the Medicaid process and planning and what we do. There's a bunch of stuff we could have talked about, but we just didn't have time.
Is there a Colorado statute or regulation where all these rules are written?
Yes. It's painful. I mean, I can tell you it is incredibly painful. There's two primary sources of stuff. One is the Colorado Medical Assistance Act, which is codified at approximately, give or take, Title 26. So if you go into Title 26, a portion of Title 26 is going to be called the Colorado Medical Assistance Act, or something close to that. Now, a more practical place to look for this, the most practical place is what we do refer to as the regs. There is a regulation for the State Department of Human Services, and those regulations are available online. They are almost impossible to find by design, I think it's by design. Nobody, and I can tell you back in the day, before computers and all that, you had to actually tape the regs. I mean, it was painful. And you had to have the current ones. It was just so incredibly difficult to get them. But it's at the CCR, which is the Colorado Code of Regulations, and I'm going to approximate it for you. This is not the precise thingy, but if you get here, it's close. I think it's 25.100. Somewhere near there are all the regulations applying to what is called the Elderly and Blind Disabled Long-Term Medicaid regulations, which is what we've been talking about. So if you can find those regulations, I can actually email a not recent copy, but one within the past year to Robbie, maybe he can disseminate it. It'll be in PDF because I get those and I download them in PDF because it is, I'm going to tell you, it's very difficult to find, but they are located, all of the Colorado regulations are located with the Colorado Secretary of State. So you can find these. Is it easy? It is not easy. It is so ungodly difficult. It's not easy. But I will email Robbie 2 things to follow up. I'll double check the homestead exemption for the homestead for married couples, and I'll go ahead and send you a PDF. It might not be the most current, but it'll be within months, so it's going to be better than nothing. And I'll email that, and he can hopefully disseminate it to your list. All right. Anything else?
Thank you.
You are welcome.